All right, good afternoon, ladies and gentlemen. I am Claudia Robinson, and I'm the judge that is presiding over the magistrates this afternoon.
They just left, so maybe they're going to come back. We're starting court. Just if you have any thoughts or anything, I just want to present the situation to you, and if I need to
Now, this hearing at
update you with
magistrate
anything,
is
I'll call
for
you if you
purposes
need
of
to
setting
update
a
me.
bond
Just,
and finding probable
whatever.
cause on those charges. So it is non-adversarial in nature. For those of you that have the public defender's office appointed to you, we're going to go ahead and hear from them. The state attorney is also present. They're going to go ahead and say a couple of things. I'm going to ask that you please, of the utmost importance, not talk to me about the facts of the case, because anything you say can and will be used against you. And then hopefully we'll try to get you out of here as quickly as possible so you can go back to have lunch and so on. So with that being said, from this morning we had Nesty Nikaj.
Judge, if I could just ask one question real quick. Mr. Bowen is here in the courtroom. He was here earlier this morning. The court transferred it to mental health court, but he's on the second look docket. I didn't know if that was a mistake or if it's if there was another case that was out there that he's here on for that.
Arton Bowen.
Let me.
Just have a seat 1 second. Just have a seat 1 second. 1 second, okay?
Yes.
Sounds good.
Brought back on the third day.
Gotcha.
So even though today was the first day for the magistrates, and because of medical recess,
Okay.
that's why he's on this document.
Okay, so we're,
The court is sending him to mental health court.
yes. So we can go ahead and release Mr. Bowen so that he can go back to the comfort of the back there so that he doesn't have to sit in the magistrate room.
Great. Thank you very much, Judge.
What did she say?
She said I'm going home?
Not at this time, but soon, Mr. Bowen, hopefully. All right. So also from this morning, we have Mr. Nesty Nikaj, who required an Albanian interpreter.
Yes, Judge.
I was just told that we're not going to have an Albanian interpreter for at least a week.
Your Honor, frankly, and I'm not trying to tell you, I would actually tell the clerk that something else has to be done, because he has to have his first appearance. We have to have I would imagine the court would be ordering no contact, and that needs to be ordered also. I understand that's what they're saying, but frankly, it's just, for the state's position, it's just not acceptable.
No, right. So, do we have the number to the interpreters?
Do you have the?
Well, Judge, I did contact my supervisor because it usually takes 2 days the first time I heard a week just to double check if she drives.
Yeah, but I think.
Okay, so let's go ahead and put Mr. Nikaj at just brief recall still. See if we can get him a better answer than that. Okay?
Great. Thank you very much,
You're
Judge.
very welcome.
And thank you, Mr. Linder.
All right, so let's go down the docket. We have Suzanne Figueroa.
Something that's happening.
You have a seat for just a minute. You don't have a seat. No.
All right, welcome, Ms. Figueroa. Ms. Figueroa, you're charged with touch or strike battery as a domestic violence. Any probable cause arguments?
1 moment.
All right, I find probable cause as to that charge, and as to the bond, Mr. Linder.
Your Honor, I don't see any history. I would just be seeking a $1,000 bond, no victim contact.
All right, Ms. Figueroa, anything, Mr. Fairberg?
Yes, Judge. I can indicate to the court that she's been a resident here for 3 years. She is single and has 2 children that are aged 15 and 17. One of her children has had a illness where I'm sure the costs are exorbitant as far as the treatment for his condition. She does work for Federal Express, but she has very, very minimal funds. I would just ask, she does have family members that live here in the area as well. I would ask the court to consider placing her on either ROR or in the alternative to place her on pretrial release with no monetary bond.
All right, Ms. Figueroa, where do you live?
In Coral Springs, Florida.
What's that address?
2801 Riverside Drive, apartment 308.
Okay, and who do you live with?
My 2 children.
Okay.
Can you afford it? Are you on probation?
All right, so, all right, Ms. Figueroa, I'm gonna give you a bond in a little bit, and we're gonna discuss your release conditions, but in the meantime, I'm gonna order that you have absolutely no contact with the victim in this case, Wanda Figueroa. That's your
Yes, ma'am.
sister.
Yes,
I'm
ma'am.
gonna order that you have absolutely no contact with her. You can't have anybody else contact her on your behalf. You can't have your mom contact her, the kids contact her, no contact whatsoever, understood?
Yes, ma'am.
All right, I'm gonna also order that you surrender any weapons that you may have in your possession. And here's what I'm gonna do. I'm gonna set the bond at $500, or I'm gonna, if pretrial release is able to verify your address, I'm gonna order that you be released to pretrial with the standard supervision of pretrial.
What they'll do is they'll go out and contact, make sure you live at that address. And if everything
If
is
you are
good, they'll
released to
release you.
pretrial,
My
I'm
mom
gonna
is
order that
there.
you, are you open tomorrow pretrial? I'm gonna order, if you are released to pretrial, I'm gonna order that you be, that you report to pretrial Tuesday morning, okay?
Okay.
Okay, you're gonna be ROR once they verify
In the
the
interim,
address.
she
If
can
they
post
talk to
the
your mom,
$500
she says they
bond,
live
yes.
there, then,
Do they need my mom's number?
Additionally, the court is not supposed to have any contact, so we'll talk to her.
hold on one second.
All right.
Yeah.
Okay, perfect.
Judge, well, she has a phone number that they can reach the mom at. I don't know if pretrial wants to just contact her, and then that way she can give it to them.
Oh, apparently I've just been advised that she was already interviewed, and they do have that information,
Okay.
so they're gonna go ahead and work on that. Thank you.
Okay. All right, that's it. Take that with you. This is a map. You have to report there first thing Tuesday morning, okay? So
Okay,
it's right across the street from the-
Alexandria
right back there.
Martinez Davis.
Right.
Release?
Oh,
Yeah.
Oh, I'm sorry,
I-
Judge. Sorry.
Oh, yeah, she's bonded.
She did bond. I'm sorry.
all right. Priscilla Andrade.
Yeah, you can get here.
Miss Andrade, you are charged with count 1 is battery on an officer or firefighter, and count 2 is trespass, which is a no charge and not for magistrate.
Martinez?
Any probable cause argument on count 1?
No.
No, not you.
Okay, great. I find probable cause as it relates to count 1, battery on an officer. As far as the bond amount, Mr. Linder,
Your Honor, I'd be seeking a $1,500 bond on count 1.
any priors?
One moment, Judge. Does pretrial have any notes?
Felon Knight was arrested for disorderly conduct, resisting without violence, and obstruction. That's the charge. Was arrested for an aggravated battery causing great bodily harm. Self-reported. Eventually, that was no problem. We were advised after we spoke with her that she has no stable residence.
All right. So she's got no priors for all practical purposes. State's request was how much? $1,500?
$1,500, Judge.
Mr. Farber?
Judge, I can tell the court that she's lived in South Florida for 27 years. She has one child that's 1 year old. She is single. She has no money in the bank. She's not currently working. She does get SSI. She just lost her job in August, and she has no money at all to afford any type of bond. I asked her if she could even afford $100, and she indicated no. What I would be asking the court is to consider an ROR in this case. If not to straight ROR, then to ROR to pretrial release.
But she has no stable residence. Where are you staying, Miss Andrade?
I'm homeless at the moment.
And where's your child?
PCF. I have one more parenting class to go to next week.
Do you have any family
she's
in the area?
Starting. I'm sorry?
Do you have any family here?
No, not at all.
She's trying to work it out, Judge, to get it, get her life back together and that's why we would ask the court to take all of that into consideration in ROR.
No, I can ROR her and order her to pretrial without pretrial having to verify a residence for her, right?
The court can do whatever the court.
I mean,
All right, I'm gonna, on count 1, I'm gonna ROR put her in pretrial with the standard supervision. So here's what's gonna happen, Miss Andrade. You're not gonna get out till really late today.
Okay.
But you need to go Tuesday morning, first thing in the morning, you need to go to pretrial release to check in, okay?
Yes, I will. I will do that.
It's right across from the courthouse.
All right.
Here's the map.
Good
Okay.
luck to you, ma'am.
Thank you.
Thank you very much, Judge.
Joseph Ramsing?
Copy, Your Honor.
Here, I'm gonna ask for an ROR on this. He completed his sentence, and the reason I'm asking for the ROR is because he will, I believe he's been in custody since October 9th. The warrant was issued November 10th.
He's completed his sentence on charge
It says
number
sentence completed on the sheriff's website.
1? On charge 1?
On charge 1. I think he's supposed to go to First Step Sober House. Are you supposed to go to First Step Sober House, sir?
No, I was released yesterday from the courthouse to go home.
Problem is, State, Mr.
Your Honor, he was in custody when this capias was issued. In custody in Broward.
Needs to go to court. When you're released, sir, you have a traffic criminal case pending before Judge Levine in the West Satellite Courthouse. You need to go there.
All right. I'm probable cause for the capias and will ROR him on this charge. Did you understand, Mr. Ramsing, what Mr. Afzal explained to you?
Not clearly, ma'am.
Okay,
Not
so
clearly,
you're
Your
going to
Honor.
be released on this charge because you
Yes.
were in custody when this capias was issued, but eventually you're going to have to answer to these charges. You're going to eventually have to go see Judge Levine at the West Satellite, okay?
Yes, Your Honor.
All right, sir. Good luck to you. Have a good day.
You too. Thank you.
You're welcome. Michael Seitz?
Main jail.
All right, thank you. All right, welcome, Mr. Seitz. Mr. Seitz, you're charged with trespassing of an unoccupied structure conveyance. Any probable cause argument, Mr. Afzal? All right, I find probable cause for that count. And the bond right now, the convenience bond is set at $25. Anybody? Mr. Linder?
I'm fine with the $25 bond, Judge.
Mr.
Judge, he wanted to know if the court's in a position to resolve this today.
All right, state.
State's offer would be 30 days.
30 days.
Your Honor, I understand he was charged with trespass. He's going into a vacant home. Your Honor, he has a significant history. So yes, the state's offer would be 30 days to resolve both.
Mr. Farberik, the state's offer is 30 days.
Judge, I don't think he wants to accept 30 days. I don't know if the court's in a position to offer him a time served sentence.
You would open plea to the court?
To do things.
Judge, if I can speak to him for just a second.
Sure, go for it.
Judge, I've explained to him what happens on an open plea, that the court basically can do anything it wants within the realm of the law. He wanted me to push for a time served, but I believe that he still wants to open plea to the court.
Okay, all right, very good. Mr. Seitz, would you please raise your right hand, sir? Would you swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth, so help you God, sir?
Yes.
All right, you may put your hand down. Sir, are you under the influence of any alcohol, medication, or drugs?
No.
Have you ever been treated for a mental illness?
No.
Can you read, write, and understand English, sir?
Yes.
So you understand everything that's going on here today?
Excuse me?
So you understand everything that's going on here today?
Yes.
All right, very good. Mr. Seitz, I informed you earlier that you're charged with trespass on occupied structure or conveyance. State has made you an offer of 30 days in Broward County Jail with credit for time already served and an adjudication. I'm assuming because that would have to be an adjudication. But you want to go ahead and open plea to the court, is that right?
Yeah, I'm just pushing for time served and all that. And
Okay.
like that, get
Right. Okay, so you don't want to take the
I can
state's
get
offer.
released.
You don't want to take the state's offer, right?
Right.
Okay. And have any promises been made to you, sir?
No.
Okay. Mr. Seitz, are you on probation or parole anywhere in the world?
No.
All right, and you understand by resolving your case today, and you understand by resolving your case, if you're not a U.S. citizen, this will subject you to deportation. You understand that, sir?
Yes, I do.
All right.
I got
right.
things to do.
Okay. All right, Mr. Seitz, as to the charge of trespass, unoccupied structure, conveyance, how do you plead? Guilty or no contest?
No contest.
All right, and as to the charge of, I'm going to do loitering, I'm going to take care of that loitering and prowling charge also, although it says no C, NC, but I don't want them
No, he's charged with.
to, right?
Yeah, the NC is a bond issue.
And as far as loitering and prowling, sir, how do you plead? Guilty or no contest?
Excuse me, how do I have lawyer? It's a trespass.
It's a trespass and a loitering. You've got both counts. There's 2 counts. So do you want to resolve them both?
Yeah, I want to solve both. Okay. Excuse me, I'm sorry.
As to the charge of
Say
loitering
again?
and prowling, how do you plead? Guilty or no contest?
No contest.
All right, I accept your plea. I find that you're fully voluntarily intelligent. We have your rights. I find that you're competent to go here and learn. I find that you know and entering this plea and understand the nature of the charges and the consequences of the plea. Mr. Farbarik, do you stipulate to a factual basis for purposes of the plea?
Hey, all I know is...
Based on his...
Judge, I would stipulate for the purpose of the plea.
All right, Mr. Afzal stipulates for purposes of the plea. Upon that stipulation, I find that there's sufficient factual basis for the plea. And count 1 will be a withhold.
Your Honor, respectfully, the court doesn't even know his record.
Well, based on your 30 days. Go ahead.
He was arrested late December for a trespass, county sentenced, was just released from custody January 1st. His record also includes trespass, criminal mischief, 2015, violation of an injunction, order of protection, trespass, 2014, stalking and trespass, 2014, trespass, 2013, trespass, 2011, burglary of a structure and resisting without violence, 2011, resisting without violence and trespass, 2011, loitering and prowling, 2010, trespass, 2009, trespass, 2009, trespass, 2008, trespass, resisting without violence, 2007, uttering a forged instrument, 2 counts, and unauthorized use of a driver's license or identification, 06, with a violation of probation. End of record in Broward County, Judge.
All right. All right, Mr. Seitz, so I will sentence you to an adjudication, time served, and court costs as to count 1, and count 2 will be withhold and waive those court costs. I'll give you 6 months to pay those court costs, and good luck to you, sir. Thank you, Mr. Seitz.
Thank you.
You're welcome, sir.
Thank you, Judge.
You're welcome. Brian Trollo?
Judge, she's
Could
over
we
at the...
also, I'm sorry, can we also take one out of turn when you get a chance? Nigel Rodriguez, the deputy of asked me to ask.
North Broward, yeah.
All right, we'll continue Nigel.
Somebody over there, I don't know why they said...
All right, let's go into Brian Trollo. Well, how are you, Mr. Trollo?
Fine.
Okay. Mr. Trollo, you being charged with 2 counts. Count 2 is burglary, unoccupied conveyance, unarmed. And count 3 is petty theft as a subsequent offense, as a third or subsequent offense. Any probable cause argument?
Judge, I don't have a probable cause argument. What I can tell the court is count 1, he's being held no bond. He's at the third. He was at the third step sober house prior to being arrested on a pretrial warrant. He's currently on disability. Whatever money he gets in disability, he pays towards third step. His attorney did file a motion to set bond on his case. I would respectfully ask the court to, I can tell you he's been here quite some time. He's currently disabled. It's not working. Was in a rehab program.
I find probable cause as to count 2 and 3 as far as bond, Mr. Linder?
Your Honor, requesting $3,500 bond on count 2. I'm not seeking a modification on 3.
What's What's number one? What-
Battery on a law enforcement officer.
And he's being held no bond? Does he have any priors?
He pled out a theft June 27th of last year. 2015 felony battery due to priors. Disorderly conduct 2015. Disorderly conduct resisting without violence 2014. Criminal mischief disorderly conduct 2014. Felony battery due to priors and felony theft 2014. Disorderly conduct 2013. Theft 2013. 2010 aggravated battery, great bodily harm, possession of firearm by convicted felon, 3-year state prison. Felony theft 2008 with a violation of probation. Disorderly intoxication 09. Theft 08. Assault on a law enforcement officer 08. Theft 08. Felony theft 08. Theft battery resisting without violence 08. Felony theft 07. End of record.
What are you asking for, Mr. Epstein?
At this time, the only money he gets is $1,000, which goes to the Third Step Sober House. All his checks are at that place right now. He hasn't cashed them. He has no way to access that money. I would ask the court. I know the state requested $3,500 bond. Will the court consider $2,500?
All right. I'll do count 2. Will be 2,000. And count 3, I'll leave at 750. Thank you. Good luck to you, Mr. Tralla. Gene Alexander.
Main jail.
All right, thank you. All right,
Judge, he
Mr.
declined the PD.
Oh, all right, Mr. Alexander. Are you going to get yourself an attorney, sir?
Yes.
Okay, who's your attorney?
I don't have one yet.
Okay, well, here's the thing. At this hearing, you would go ahead and get a bond on these charges. Right now, the charges, there's no convenience bond on these. You're charged with aggravated assault with a deadly weapon without intent to kill. Count 2 is touch or strike battery as a domestic violence. And count 3 is false imprisonment of an adult. Those are serious charges, and you're looking at the bond amount. Do you want an attorney? You want me to reset you for tomorrow so that you can get an opportunity to talk to your attorney?
What's the bond?
We're not going to get to that point until you tell me, answer my question first. Do you want to reset tomorrow? It's not like you can't see what's behind window curtain number 1 before you decide whether you want an attorney or not. You need to tell me whether you want an attorney first or not. Do you want to?
No, let's just set the bond now and then I'll take the attorney after.
All right. And you don't want to proceed? You don't want the assistance of the public defender's office?
No. No.
Okay, very good. All right, Mr. Alexander, I find probable cause for counts 1, count 2, and count 3, the false imprisonment of the adult. Mr. Linder, as to the bond amount?
Does pretrial have any record? Okay. Your Honor, even assuming he has no criminal history, I've got great concern for the alleged victim, Your Honor, based on these allegations, the level of violence, allegedly using a firearm. I'd be requesting a $25,000 bond on 1, $2,500 on 2, $7,500 on 3. No victim contact. Should he post his bond, pretrial release with a GPS monitor.
All right, Mr. Alexander, momentarily we're going to go ahead and discuss your bond, but I want to go ahead and discuss... Okay. So, Mr. Alexander, momentarily I'm going to go ahead and talk to you about the monetary bond, but I want to go ahead and emphasize, be very emphatic, Mr. Alexander. You are to have absolutely no contact if you're able to post the bond that we're going to discuss in a little bit. You're absolutely to have no contact with Tiara Gibson. You understand that, sir?
Okay.
You can't have anybody else contact her on your behalf. You cannot contact her via Instagram, Facebook, text message, nothing. You cannot contact her, and I'm going to order that you surrender any and all weapons that you may have in your possession. Understood?
Okay.
All right.
Yes.
Now, the state's requesting a bond. Their position is that they want a bond of $25,000 on count 1, $2,500 on count 2, and count 3 is a $7,500. They're requesting a $7,500 bond. So, do you have? It would be for a total of $35,000. What are your ties to the community? Who do you live with?
I live by myself.
Where do you live by yourself?
On 1993 Northwest 183rd Avenue, Pembroke Pines, Florida 33029.
Is it 183rd Avenue or 23rd Avenue?
183rd.
Okay. And do you have any family here?
Yes,
All right. What's your family?
I have my cousin, Patrice Noel, and I have my auntie.
All right. And do you have a job?
Yes, but Your Honor, I will ask you if you can lower the bond for me because on Monday I just they just sell my house, so I just lose my house on Monday with foreclosure. So I would like to see if you can lower the bond for me a little bit.
How much can you afford?
Maybe if with the bail bond of $20,000, it's 35. Maybe if you can do it for me for 15, because I never get in trouble before with domestic violence. I'm 35. It's the first time I'm going through that problem, and then I never get in trouble, nothing like that. So I think you should give me a little break, please.
All right. So here's what's going to happen. I'm going to give you a monetary bond on each count, and I'm also going to order, Mr. Alexander, that once you are released, if you're able to post the bond, that you be placed on pretrial release with level 2 supervision, which means that you're going to have an electronic monitor, and they're going to be able to know exactly where you're at, and that condition that you have no contact with Miss Tiara Gibson is
Okay, no.
also imposed, okay?
Okay, no problem.
All right. So count. Count one. Count one is going to be $20,000. Count two is going to be $2,500, and count three is going to be $7,500. Thank you, Mr. Alexander. Good luck to you, sir.
Thank you.
Judge.
John, Mr. Fairbank, did you request to take out a turn?
Yes, Mr. Nigel Rodriguez.
Nigel Rodriguez.
He's on the second look docket.
Yeah. All right, Mr. Nigel Rodriguez is on page 3 of the second look document.
You always get to put second documents.
Hey, Your Honor.
All right, hi, Mr. Rodriguez. All right, so Mr. Rodriguez is charged with possession of cannabis kilograms or less, first degree misdemeanor, and count 2 is possession of drug paraphernalia as a first degree misdemeanor. Anybody? So what happens with the second? What was it set? What was it? What was the bond originally set at? State.
Judgment.
Your Honor, frankly, if he's inclined to resolve it, the state's offered me to withhold costs on both counts. The only thing I would advise the court, if you could let Mr. Rodriguez know, he's got an open felony. He was arrested in November. I believe it's on drug charges. It remains unfiled. He just needs to be advised, if he pleads this out and should that case be filed, it could have an effect on his sentence in that case. But
All right, can you discuss that with Mr. Rodriguez, Mr. Fairberg?
Judge, I have, but give me one more second. Let me just, one more
Absolutely.
time.
Take your time. Thank you.
Judge, he wishes to accept the offer from the state.
All right, Mr. Rodriguez, would you please raise your right hand, sir? Do you swear or affirm the testimony you're about to give us the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
All right, Mr. Rodriguez, are you under the influence of any alcohol, medication, or drugs?
No.
Have you ever been treated for a mental illness, sir?
No.
Can you read, write, and understand English?
Yes.
So you understand everything that's going on here today, sir?
Yes, I can.
Okay. All right, Mr. Rodriguez, you're on the second look docket, and I informed you that you're charged with possession of cannabis 20 grams or less. That's a first-degree misdemeanor, which carries a maximum incarceration of 1 year in Broward County Jail. And possession of drug paraphernalia, also a first-degree misdemeanor, which carries a maximum incarceration of 1 year in Broward County Jail. State's offers a withhold of adjudication and court costs on both counts. And you wish to accept that offer, is that right?
Yes.
All right, you may put your hand down. It's okay.
Oh,
All right.
okay.
Mr. Rodriguez, you understand that this can be used against you in the future if you, for example, if that felony charge that is pending is finally charged. You understand that?
Yes.
All right. You've had enough time to talk to Mr. Fairberg about this?
Yes, I have.
All right. And you're satisfied with his services, sir?
Yes.
All right. Very good. All right, Mr. Rodriguez, are you on probation or parole anywhere in the world?
No.
All right. And if you're aware that if you're not a U.S. citizen, this will subject you to deportation. You understand that, sir?
Yes, I do.
Okay. All right, Mr. Rodriguez, as to the charge of possession of cannabis 20 grams or less, how do you plead, guilty or no contest?
No contest.
All right, as to possession of drug paraphernalia, how do you plead, guilty or no contest?
No contest.
All right, I accept your plea. I find that you're fully voluntarily intelligent, waive your rights. I find that you're competent, coherent, alert, and I find that you know the nature of this plea and understand the nature of the charges and the consequences of the plea. After reviewing the charge, counsel, you stipulate to a factual basis?
All
Judge,
right.
we would stipulate based on, for purposes of the plea.
All right, upon the stipulation, for purposes of the plea, I find that there's sufficient factual basis and sentence you according to the negotiated offer of a withhold of adjudication court costs in count 1. And count 2 is a withhold of adjudication and court costs. I'm going to give you 6 months to pay those court costs, sir. Good luck to you, okay?
All right. Thank you, Your Honor.
You're welcome,
Good
sir.
luck.
Take care. All right. John,
Thank you, Judge.
you're very welcome. John Cordero?
Main jail.
Good afternoon, Your Honor.
Good afternoon, Mr. Cordero. How are you?
Doing well. How are you?
I'm very well, thank you for asking. Mr. Cordero, you're charged with possession with intent to sell, manufacture, or deliver cannabis. That's count 1. Count 2 is possession of LSD. And count 3 is causing child to become delinquent or dependent or needy. Any probable cause arguments, Mr. Upsall?
Judge, I don't have a
There we
probable
go.
cause. I don't have a probable cause argument. Would the court take into consider the age difference with regards to the contributing to the delinquency of a minor? It's not a big age difference, 4 years, maybe a little bit less than 4 year difference between the two of them.
All right, well, I mean, I still find probable
No,
cause
no, no.
for
I'm just
count
saying
1.
for mitigation purposes,
Okay.
yeah.
All right. As to the bond, Mr. Linder?
Your Honor, I'm not asking for any bond increase.
Okay. Who's that? His brother? Oh, I'm so sorry. Oh, Mom, how are you? Come on up. All right, Mr. Cordero, you have your mom here. You're very lucky.
I see her.
Not many moms come to visit, but welcome, Mom. What's your name?
Julia Cordero.
All right, Ms. Cordero. So I did find probable cause on both of those on all 3 charges. And now we're going to go ahead and discuss the bond. The state has no argument to increase the bond. Mr. Fairberg, you want to be heard?
Judge, I would just tell the court that he's been a resident here for 14 years, that he is single. He has some money in the bank, but not a lot. He does work construction, and he does plumbing work as well. And as the court can see, his mom is here in the area. I don't believe he's a flight risk.
Any priors, state?
I don't see any priors out of Broward. I don't know if pretrial had anything different.
Judge, if he has no priors, I would ask the court to consider RORing him.
All right, Mom. Is he going to go back and live with you?
Yes, ma'am.
right, so right now, Mom, the bonds are set at $1,000 for count one, $1,000 for count two, and $100 for count three. Can you afford that? And he has no priors?
Yes, no adult priors, never been arrested, no.
Well, he's only been an adult for not that long. All right. So, pretrial release is here if they're able to. I'm going to leave the bonds as is, 1,000, 1,000, and 100.
The mother is here, Your Honor, she did place that we can contact the court with her.
Okay, so if you're able to talk to her and verify the information with her, how does that work?
I believe you can just speak with her right now if the court wants to, because we would be calling her and ask her where she is.
Okay. What's your address, ma'am?
11500 Southwest 13th Place. That's in Davie.
Okay. And he's going to be staying with you there?
Yes, ma'am.
Who else is living there with you?
His father, my husband, Joseph Cordero.
Okay. All right. So I'll release him to pretrial release to his mother with standard supervision, which means that he's going to have to go ahead and report to pretrial release Tuesday morning, and he's going to have to report as long as they tell him to report, and they're going to randomly urine test him. So if he violates any of those conditions, he's going to be back in custody waiting the pendency of this hearing.
Don't worry, he won't do it again.
Okay. All right.
I
Thank you.
think he learned his lesson today.
All right. Thank you very much, Ms. Cordero. Mr. Cordero,
you.
good luck to you.
Appreciate it.
You're welcome.
Okay.
Where do I go?
That's it.
Travis
Right out the
Grace?
back door, and they'll release you in the next probably 2 hours.
All right, Mr. Grace, you're here charged with 2 counts. Count 1 is aggravated assault with a deadly weapon without intent to kill, and count 2 is aggravated assault with a deadly weapon without intent to kill. Any probable cause argument?
Judge, Mr. Grace indicated he's going to hire private counsel.
All right, Mr. Grace, are you going to get your attorney to come and talk to the court on behalf of you for bond purposes?
I'm not gonna hire nobody. I'm gonna let you talk. Yeah,
Judge, he wanted the public defender now.
Okay, all right. You know, it's very quick how people change their minds.
Yeah.
That's okay.
Yeah.
Oh, yes, sorry. All right, Mr. Grace. So I do find probable cause on both of those charges. As to the bond, Mr. Linder?
Your Honor, I'm going to be seeking a $25,000 bond per count. Pretrial release of the GPS monitor, no victim contact, based on the allegations, including but not limited to the allegation that he actually discharged his firearm at the alleged victims. His criminal history: 2006, delivery of cocaine, delivery of a counterfeit controlled substance, 18-month state prison. 03, delivery of cocaine, 30-month state prison. Resisting without violence, 03, delivery of a counterfeit controlled substance, 2000, with a VOP, 30-month state prison.
Mr. Farberic? Did you get any information on the other one?
I talked to the team leader, she said it was
Oh, okay. She said next week.
Until you call back and say, look.
Well, she put here reset for 1/14/2017, which is tomorrow. But then she said to me, she goes, can you reset it for next week? And I'm like, oh my God, it's gonna take him a week, but.
First time we're late. Sometimes they don't realize how urgent it is. I'll just leave it. Oh, I get it. And I wasn't necessarily expecting to have someone by tomorrow, but a week is just, that's, when it comes to.
All right, Mr. Farberic?
Sorry, I didn't know you were waiting for me, Judge.
Oh,
I'm
no,
sorry.
it's okay. That's okay.
He's lived here in South Florida all of his life. He has one child that's age 7. He indicated that he only has about $500 in the bank. That would be all that he could afford with a bondsman. He indicated that he also lives with his mom and his grandmother. His grandmother is blind in both eyes, and he's the one that cares for her. When his mom goes out to work, he's the one that's there to help feed her in that, because she can't see to get around and to get to her meals and that. So I would ask the court to take that into consideration. Based on the amount that he says, I would ask the court to set the bond no more than $5,000. That would be what he could afford, to possibly bond out.
Okay. All right, Mr. Fairberg, although you make a very compelling argument to the court is very bothered with the fact that, interestingly enough, I had a gentleman in my division that came into court. He missed court for whatever reason, and he came into court trying to have that capias vacated, and part of his compelling reason was that because he lives in Dania. And apparently in Dania, there's a lot of police activity there because of what's been going on. And this incident occurred in Dania, which I find very troubling, and the facts of the case. So what I'm going to do is I'm going to respectfully deny your request for the $5,000 bond. I'm going to set count 1 at $20,000, and I'm going to set count 2 at $20,000 in the event that Mr. Grace is able to post that bond. I'm going to go ahead and order that he be put on level 2 electronic monitoring. He have absolutely no contact with the victim, Bernard Williams and Sheila Annette Dees, and I'm going to order that he stay away from that. Can I do that? Okay, let's order him to stay away from that area.
Just one moment here, let me see.
I'm not gonna tell him to stay away all the way from Dania Beach, but just from the house where they're at.
You live in there?
The problem, see, I'm not as familiar with Dania Beach, Your Honor. I frankly, I don't know that the court really can at this point anything more than no contact with the alleged victims.
All right, no contact with the victims. Thank you. Okay, Mr. Nesty Nikaj, we got an answer. I feel so bad because Mr. Nikaj needs an Albanian interpreter, so he probably doesn't even know what's going on. All right, Mr. Nikaj, we're gonna see you back here tomorrow, hopefully with an Albanian interpreter, okay?
No, I need to finish today.
Yeah, I know.
Judge, he speaks some English, but I have tried to talk to him, and when I try to explain it in very basic terms, he doesn't understand what's going on, and it's not because he's not able to understand. It's a language barrier.
Right. No, we're going to go ahead and wait till tomorrow. Listen, it's going to be one more day. I know that it's a little inconvenience, but because of the nature of the charge, it's a touch or strike, battery, domestic violence, there are going to be a lot of conditions that are going to be set on your release that I really want you to be sure that you understand to prevent any future confusion in the future, okay? Thank you, Mr. Nikaj. We'll see you tomorrow, sir.
Okay. You'll be back tomorrow, okay?
Jordan Boschnack. All right, Mr. Boschnack, you're being held on 2 counts of violation of probation. Count 1 is a violation of probation on 09019043CF10A. You're being held no bond on that. I find probable cause for that BOP warrant. Count 2 is a violation of probation on 110157947CF10A. You're being held no bond on that. And I find probable cause for this BOP warrant. Although you're being held no bond, sir, the good thing is that you're going to go see your division judge on January 18, 2017. All
Your
right,
Honor,
sir. Good luck to you.
This is the case that Mr. Jellin was here on this morning. I don't know if,
1 second.
he mentioned me. I don't know. Yes, this is.
Oh.
He had mentioned something about like he was going to be called or something.
That's okay.
You're supposed to call.
All right, hold on, Mr. Boschnack. Let me try to get your attorney.
Understand.
Good morning, Mr. Jellin. This is Judge Robinson over at Magistrate Court. How are you?
Hey, Judge, how are you? Thanks for letting me appear by phone.
Absolutely not a problem. I just had Mr. Boschnack, and Mr. Linder was the one that actually reminded me, and I do apologize for having gone through practically the whole proceeding without calling you first.
Thank you, Mr. Linder.
No problem.
All right, Mr. Boschnack is charged with 2 violations of probations in 2 cases, 09019043CF10A, where he's being held no bond on that warrant that was signed by that judge. And on count 2 is another violation of probation It's both Judge Merrigan's cases where he's being held no bond also, and that's on case 11015794 CF10A. So as you know, I can't touch those bonds, but the good news is that Mr. Boschnak has a court date on January 18, 2017 at 8:45 a.m.
Okay, that's, if you can hear me, George, Judge Robinson can't release you even if she wants to, that's what she's saying. Only Judge Merrigan can, so I will see you on the 18th with Judge Merrigan.
Did you hear Mr. Bishop? Okay, yes, he's nodding and he's saying yes.
Yeah, he did. I'm sorry.
That is correct, the 18th at 8:45 a.m.
Okay, thanks everybody. Have a good weekend.
You're welcome, take care.
Okay, just a second.
Christopher Lee Stone.
I can ask. Judge, this is a, count 2 is a municipal ordinance, and again, I would just indicate to the court that there's nobody here from the city attorney's office, as well as there's nobody here to represent Mr. Stone. I would ask the court to dismiss the charges because there's nobody here either to defend them or to prosecute them. And I would also ask in the alternative that the court ROR him on those charges. He did indicate that he...
It's already no charge. Yeah, it's not for magistrates.
So there's no bond attached to it.
Right, there's no bond attached to it. My intent is not to attach any bond to it. He'll be able to take care of it with Judge Backman because it's a Hollywood arrest. Yeah.
I just realized that there's also a felony attached.
Yeah, and the felony is the possession of cocaine. Any argument as to probable cause, Mr. Upsall? All right, I find probable cause as to the possession of cocaine charge. The bond right now is $1,000, Mr. Linder.
No, Your Honor, he's got a record. Your Honor, I'm gonna be asking that the $1,000 bond be kept in place. His criminal history includes 2014 theft, 2014 possession of cocaine, 20-month state prison, 2014 possession of cocaine, he violated probation, 20-month state prison, 2008 possession of cocaine, alprazolam, marijuana, battery, resisting without violence, 2008 possession of alprazolam, 2000 grand theft auto with a violation of probation, 2000 resisting without violence, possession of stolen credit card and theft, 97 aggravated fleeing and eluding, grand theft auto, resisting with violence, violation of probation, year and a day state prison, 1997 burglary of a structure.
Okay, Mr. Farbera, you want to be heard on Mr. Stone? I'm not inclined to touch the $1,000 bond.
Judge, if I can have one more second with him.
Sure. I'm not inclined to increase it. That's what I should say.
Judge, I can tell the court that he's lived here all of his life. He has no money in the bank. He's not currently working. His mom does live in the area. He did indicate to me when he first came up, and that's why I had brought up about the municipal ordinance, that he wanted to try to resolve it. I just didn't realize that there was a felony attached to it. He did ask me, because he has no money, if the court would consider an ROR.
No, Mr. Stone, not at this time. I'm not gonna increase the $1,000 bond. I'll leave it at $1,000, but hopefully you'll get to see a judge sooner than later. Okay?
Thank you.
Take care.
I couldn't do drug court? I couldn't do drug court now?
They figure that gets decided at a later date.
When you go to court, just ask them to see if you're eligible. The state attorney will see if you can go into it, because it also depends on his priors.
That's what I'm saying. It's a whole screening process.
Okay? I can't appoint your office, can I? Oh. Okay, on count 2, I'll appoint Mr. Shade on the municipal ordinance, since he has the public defender's office on count 1. All right, Xavier Edwards.
Hello.
All right, Mr. Edwards, welcome. Counts 1, 2, 3, and 4 are out-of-county holds from Volusia County. You're being held no bond on those. I can't touch those. I find probable cause for those out-of-county holds. Count 5 is a capias on a misdemeanor, 160109113 MO 10A. The bond is $2,000. And count 6 is a capias on the same case, and the bond is $2,000 on that as well. I'm not touching those, but the good thing is that you're going to go see the division judge on January 18, 2017 at 9 a.m. Good luck to you, sir.
But tell her, dismiss me, I want to solve it.
If I can have 1 second to explain it to him, Judge.
Sure, thank you.
Yeah, okay.
Those are municipal ordinances.
You're welcome. Ms. Edwards?
Whatever happened with?
We're
I thought you guys were just here observing because.
Judge, what
it's
he's
very
asked me,
fascinating.
what he's asked me, and again, we don't represent him on the municipal ordinance cases, but what he's asked me is, these are holding him up from going out to the out of county. He wanted to try to resolve them today. I did explain to him that it could affect him. He indicated that they're all new charges, so it could add 0.2 or 0.4 if you resolve both of them to a score sheet.
No, you'll have an opportunity to address these charges on the 18th when he goes in front of his judge. Thank you very much, Mr. Fabarek, for addressing this in front of the court. Good luck to
No
you,
problem.
Mr. Edwards. Take care. Javier Casanova.
She's at the Paul Ryan facility.
Yes.
I can tell you one of his counts is no bond hold.
All right. This is an add charge of count 2.
It's a change of
There
charge.
are two change of charges, Your Honor, if I may. When he came through, they were misdemeanor batteries. Because of priors, they've been upfiled to felony battery. All I'm asking, Your Honor, even though the bonds have been raised, I'm asking the court just to reset the bonds at $1,000 each.
All right. So I find probable cause for the upcharge of those charges, seeing as how the basis is the prior battery charges. And $1,000 each, Mr. Otto?
Yeah.
I believe his attorney filed a motion to reduce bond, so I'll ask the court to leave it the same and let them take care of it in division.
And Your Honor, just for record purposes, the reason I'm not asking for a bond increase is I have reason to believe that Judge Lerner Wren was informed of his priors when she set the bonds and was aware that there were prior batteries.
You said his, Mr. Abzal, you said his attorney filed a motion to.
No, I'm sorry, Judge.
All right, I mean, I'm gonna set the bond at $1,000 each. All right, Mr. Casanova, good luck to you, sir.
Your Honor,
Thank you.
wait, if I could just check one thing, I just want to make sure that there's already a, yeah, since these charges were upfiled. Yes, it was already ordered at his first appearance.
All right.
Thank you, Judge.
You're very welcome. Anthony Kyra.
Judge, I can't read the probable cause affidavit that was provided to me. It's all whited out.
Do they have one?
I think they have the same copy. I'm gonna argue there's no probable cause.
Volkswagen Jetta involved.
Unbelievable.
And that's all I could gather.
Then, Your Honor, I'm going to ask for time to perfect. I'm going to ask to have it reset for Sunday.
Okay.
We reset it for tomorrow?
Yes, reset to tomorrow.
All right. It's not like all he has to do is just give
Just contact the jail.
a legible
They probably have the
police
original
report.
With the sticky on it still.
What we have is what the jail has. That's what's in the what the jail has is what's in their file.
Well, somebody has
Yeah,
the
that's
original
it.
probable cause affidavit with a little sticky on it, and they just need to remove the sticky, make a photocopy of it, and send it back to us.
I understand, Your Honor, but
We'll see you tomorrow, Mr. Cairo. We can't see the information on your case, but hopefully tomorrow you'll get this resolved. All right, sir?
Your Honor, they didn't even find me in a car.
Oh, what? Don't talk to me about the facts of the case, Mr. Cairo. We'll see you tomorrow. You'll have an opportunity to discuss your case then, okay?
I guess so.
All right, take care.
hey, this is Eric Linder. I need to get a call back from Deputy. It's urgent.
Guess it could have been worse. Raul Ponce?
Hold on one second. Your Honor, if I may, as a friend of the court, this was handled yesterday by Judge Miranda. He's already out of custody. You there?
He's already out of custody?
He has been released, Judge.
954-257.
All right.
8110.
All right. So now we have, prior to going
17631.
On to the to the two.
Anthony Kyra, C-A-I-R-A.
Well, let me do the ROR docket. Only two on there. Okay, just give me 1 second. Roy Addison.
C-A-I-R-A.
Main Joe.
Yep. All right. Have charges been filed on Mr. Addison?
Your Honor, if I could have 1 moment.
Sure.
Oh, maybe not. You get right.
He was arrested January 11th. Your Honor, Mr. Addison could be ROR'd.
All right, very good. Mr. Addison, I'm RORing you on the charges. That doesn't mean that the charges
sorry,
are, well,
one
you're
moment.
explaining to him, right, Mr. Fairbark, basically that they could.
I can explain it, Judge, sure.
Perfect, very good. Congratulations,
Okay.
Mr. Addison, you're getting out today. Have a long weekend. Lanisha Bullard.
North Broward, Your Honor.
All right, very good.
It's
How are
a
you, Ms.
statewide
Bullard?
case.
Hi, Officer, Your Honor.
I'm doing well.
It was yesterday.
All right, Ms. Bullard.
She can be ROR, Judge.
All right, Ms. Bullard, I'm going to go ahead and ROR you on these charges because they haven't filed charges yet. But that doesn't mean that you're scot-free. That just basically means that they could file charges after the fact. So this charge may be pending eventually, okay? But for now, you're going to get to go home.
Okay. Thank you, Your Honor.
You're very welcome, ma'am. Good luck to you. All right, so before we move on to the other regular docket, let's go ahead and talk about another situation. We're going to go sidebar just for purposes of... All right, we're back on the record. All right, let's go from the top of the second look docket. We have Sharik McDowell.
That's Conti, Your Honor.
All right, we're in Conti. We're traveling to Conti. How are you, Mr. McDowell?
Hello.
All right, Mr. McDowell, you haven't been able to postpone on this charge?
No.
All right, you want to go ahead and resolve your case, sir?
Yes.
Lodging on private property. All right, Mr. McDowell, would you please raise your right hand, sir? Do you swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
All right, sir, you may put your hand down. All right, are you under the influence of any alcohol, medication, or drugs?
No.
Have you ever been treated for mental illness?
No.
Can you read,
I
write,
mean,
and understand English?
Yes, I can understand.
All right, so you understand
English.
everything that's going on here today, sir?
Yes.
All right, you understand that you're charged with a municipal ordinance as it relates to lodging on private property, which would subject you to a maximum incarceration of 60 days in Broward County Jail. You understand that, sir?
Yes.
All right, and you want to go ahead and resolve your case today?
Yes.
All right, you don't want to take it to trial?
No.
All All right, you understand that if, are you on probation or parole anywhere in the world, Mr. McDowell?
No, I'm not.
All right, and you understand that if you're not a U.S. citizen, this will subject you to deportation. You understand that?
Yes.
All right. Sir, as to the charge of municipal city ordinance, violation of municipal city ordinance as it relates to lodging on private property, how do you plead, guilty or no contest? Guilty or no contest?
Contact.
No contest?
Contact.
Okay, very good. No contest. I accept your plea. I find that you're fully voluntarily and intelligently waive your rights. I find that you're competent to come here alert, and I find that you're knowingly entering this plea. And understand the nature of the charges and the consequences of the plea after reviewing the charging document. I find that there's sufficient facts to defer your plea and sentence you to a withhold of adjudication. Court costs, I believe the municipal court costs are like what, $70? $78. And I'll give you 6 months to pay those. All right, Mr. McDowell. Good luck to you. You should be released today. Okay?
Yes.
All right. Take care, sir. James Hancock.
Main jail.
All right. Going up to the main jail. Mr. Hancock, you, sir, are still in custody for the charge of petty theft. That's a first-degree misdemeanor. What are we doing with Mr. Hancock?
There's really probably nothing that can be done at this point. He's got an out-of-state hold, I believe, on a violation of probation for statutory rape.
Judge, I don't know if the court would consider RORing him on his petty theft charge so that he could get back to Georgia. This is a petty theft, I think.
It
But so that he
doesn't
can get back to...
Yeah.
I've just been advised that he cannot go out of state on an ROR. It has to be disposed of.
And that's why...
That puts him in a bad predicament because, as the court knows, that if he were to plea, that obviously affects the violation of probation. So...
Yeah.
On to division.
Yeah, Mr. Hancock, even though you may want to resolve it because it may appear appealing at this time, the fact that you would be resolving it may be used against you to violate that other situation that you have in Georgia. So hopefully you'll be seeing... The good news is that if they don't file charges within 30 days, then hopefully...
I'm sorry. It's,
all right, Mr. Hancock?
If he hasn't yet, he'll have an extradition hearing next week.
All right. Take care, sir.
Thank you, Judge.
You're welcome. Michelle Clark?
She's over at the Paul Ryan. If I could just, I don't remember if this case was before you or not. She's represented by Regina Tomanakis. This is the case where she was at she was at her girlfriend's place. There was a trespass warning. The owner is deceased.
I don't think that's what this allegation is. I could be wrong, but
I don't remember that allegation.
it was before Judge Canner.
Oh, okay.
Could I speak?
No, ma'am.
Excuse me, Judge.
No, I'm going to advise you not to. This is on the... All right, you retain Ms. Salmonakis to represent you, Ms. Clark?
Only at magistrate, but not now.
No.
So what happens when she's gone? Well, I'm not sure she's got any recommendation.
I just know that I guess it appears that Judge Canner had some concerns because he set the bonds on each count at $500. Well, based on the allegation, I think there were some concerns there also.
Judge, I know but the place where she was arrested at, where the trespass is, she resides there with her partner.
Because it was at the Seminole Indian Reservation?
Yes, she lives there with her partner. The person she's passed away. That's what I've been advised of.
Well, it appears that she may have resided there, but it's the other person's home, and she was trespass warned from that home.
Does she have any priors?
Person who didn't want them, is currently deceased. Now, the property transferred to the girlfriend wants her there. That to me is a defense.
Well, yeah, but that's not for purposes of bond or, and if you want to explore that defense, it can go to division.
She's, okay.
But, hold on, we're gonna go sidebar really quick. Hold on, Miss Clark. Back on the record, so what do you want to do? Mr. Upsall?
Just with the court reduce the bonds. She's told me that her girlfriend was working on bonding her out. But they're having a tough time coming up with the money. I believe the bonds were $500 each count.
I don't know that there's any new information that's been provided that wasn't available to Judge Canner. Yes, hi. My name is Eric Linder. I'm an assistant state attorney. Support. Yeah, it's a BSO. I was hoping if I give you the offense.
So what's the other alternative? Their position is that there's been no change in circumstances.
-1474.
I mean, can I reduce the bond?
Well, I'm 10-1701-14.
Puts it on there, puts it on the second look docket, and they say, well, there's a change of circumstances. They do it because of the nature of the charge, and the court can decide what they want to do. I mean, I can't, you know, a lot of times courts resolve cases, there's not a change of circumstances. And the same information I'm telling the court, I told Judge Canner, but it's up to the court, whatever the court wants to do. Circumstances, the $500 bond is a bond she can't afford.
I don't recall that Judge Kenner wasn't informed about her financial situation at the time he set the bond. I was aware of it and still set the bonds. No, it's a grand theft audit.
I find, all right, I'm not gonna. I understand, Mr. Upsall, and you make a very compelling argument, but I am a little bothered with the reading of the probable cause affidavit. So I'm gonna let it go to the division judge, which will now be Judge Carpenter-Toy, I believe. Judge Robinson.
Yeah, if it was assigned to Judge
Carpenter-Toy. All right, Ms. Clark. Keep in touch with your attorney, okay, ma'am?
Okay.
Thank you.
Judge, they do have one over at the main jail, Nicholas Goldsmith.
Yep, he's next. Sorry, Nicholas Goldsmith.
How you doing, Your Honor?
I'm doing very well. Thank you for asking, Mr. Goldsmith. How are you?
I'm doing fine. All right.
All right, good. Mr. Goldsmith is here on the second look docket for the same charges: resisting, obstructing without violence, a first-degree misdemeanor, and trespass in a structure or conveyance occupied.
Your Honor, I'm going to ask the court not to take any action. This is Mr. Goldsmith's fifth arrest since September 17th of last year. He was just released from jail, one moment, December 27th on an ROR motion where charges of aggravated battery on a law enforcement officer, possession of cocaine, drug paraphernalia, resisting with violence, and resisting without violence are still pending.
Okay. Mr. Ferberg, Mr. Afzal, anything on that?
Judge, I can tell the court that he wanted to try to resolve it today. I don't know if the court would be inclined to do that. And the alternative, he was going to ask for it to be ROR'd if the court wasn't inclined to resolve it.
He's got those cases pending?
A filing decision has been made, but I think it is worth noting that within 2 weeks of his release, knowing that they're still pending, he's getting, again, an issue with law enforcement.
And how was he released on those other ones?
ROR, because we hadn't filed within 30 days. I can tell you, Judge, he was ROR'd. He was arrested in November on a drug paraphernalia, ROR'd. Gets arrested shortly thereafter on the case, about 10 days later on the aggravated battery law enforcement officer. He's arrested October 17th of last year.
Yeah.
Pleads out is resisting without violence and loitering or prowling. Gets out October 21st, then gets arrested in November for the new charges.
All right, I'm not gonna take any action at this time, but I'm gonna respectfully decline your request, Mr. Ferberg, but not because you didn't try. I'm just gonna decline that request at this time.
No, thank you very much, Judge.
You're very welcome. Good luck to you, Mr. Goldsmith.
You're just going to go out to division, to your regular division.
Ricardo,
Probably in about 30.
Deliz.
Conti?
All right. All right, Mr. Ferberg, I think that's it for you. Thank you very much. Have a good weekend. All right, and we're at Conti with Mr. Deliz. Mr. Deliz is charged with leaving the scene of an accident. That's a second-degree misdemeanor and an infraction for license suspended without knowledge. Can I see his?
Your Honor, I'm going to be asking the court not to take any action. The judge that heard his first appearance felt this was serious enough to raise his bond to $5,000.
Judge, can I just proffer his ties to the community, and the court can make a decision.
Sure, as a competent attorney that you are, Mr. Afzal, I'm very familiar with you. You would have probably made the same proffer to the judge at the time, and
I didn't speak with him last time. I don't recall speaking to him. Maybe the attorney at the jail spoke with him, but I don't know if the same information was conveyed. But it's up to the court. If the court's
you can.
Judge, I can tell you that he lives with his two little brothers, his mother and his boyfriend in Hollywood, and residing there for 5 to 6 years. Prior to his incarceration, he was employed with a company called Greco. They do property management. They go all over and fix properties. He was making about $300. He was making some money doing that. $300 he would contribute towards rent. His mother is currently not working. He does have a 3-month-old who is with his mother now. They all reside in Hollywood. And he was trying to raise money to get to meet the requirements of the $5,000 bond. It's a bond he can't afford.
You know, I don't think that I can do that without a. I mean, I don't. I know that y'all do this because of the possibility of resolving it. I'm not going to resolve it. I wouldn't resolve it, seeing as how there is a victim in this case, and I would want the victim to have an opportunity to be heard regarding the incident. And as to the bond that was previously set for $5,000, I don't. Yeah, I'm sorry. All right, Mr. Deliz, you're gonna go see the division judge soon, I hope, okay? Take care,
Yes,
sir. All right, so with
It was
that.
nice to see you, Judge.
Yes, Mr. Ferberg, nice seeing you too. You look good.
Thank you you as well.
All right, have a
Take
good long
care.
weekend, everybody. Thank you very much for all of your help. Good night.
Thanks, Judge. You have a good to see you.